You as an officer have been called to respond to a suspicious package left unattended in a public area. When you arrive on the scene and are dealing with the package, a man starts photographing you with his camera or his phone. Later, he will indicate that he actually works for the media and he's just curious as to what the officer's doing. However, the officer doesn't know that at the time. The officer simply knows that the man is taking pictures.
You're gonna hit me? I'm sorry, are you gonna threaten me?
As an officer, you have two options here. One is to continue on to your vehicle, deal with the suspicious package that you now have taken custody of, and move on. The other option is to confront the individual who's taking pictures and is obviously agitated, perhaps as the result of something you said, although obviously we don't see that in the video.
Officer?
Are you trying to cause a scene right now? Because I'll arrest you for disorderly instead.
Based on what you've seen thus far, would you have probable cause to make an arrest for disorderly conduct of this individual who's filming your conduct in a public place?
Why? I'm doing what I'm doing my...
No, you're attempting to cause a scene here with these
No, I'm not.
people.
You just threatened to hit me.
You most certainly are.
You just threatened to hit me.
Here's another opportunity to walk to your car and go about your business in dealing with the suspicious package. Would you do that, or would you continue to confront this individual?
You threatened to bash me.
201 from 222.
Would it be a good idea to call for a supervisor?
I don't get threatened in public. Sorry.
Would you respond to in front of the box lunch? Stop taking my photograph.
Nice to the officer. Be a gentleman.
Yeah, well,
Yeah.
that goes both
that's
ways.
The problem right there.
That goes both ways.
Get that camera out of my face.
Based on your training, would continuing to argue with this individual and insulting this individual be likely to escalate the situation or de-escalate the situation?
I'm on public property. I can do what I want.
That's not public property.
I am now.
You are so rude. Are you recording me?
I'm in public. I'm a news person.
Hold on.
Based on your training and your policy, would you have reasonable suspicion to detain this individual while awaiting the arrival of a sergeant?
Are you recording right now?
I am videotaping, which is in my constitutional rights.
It most certainly is not.
It certainly is. In public, I have the right to record video and ambient noise, and
This is not
law enforcement.
Is this photographer right? Does he have a constitutional right generally to film an officer in a public place while the officer is carrying out their job?
Law enforcement has no respect, no expectation of privacy when you're doing your job. You're in uniform. You just threatened to bash me in the face, officer. That is a crime. Just because you have a badge does not mean you can threaten people to bash them in the face.
I hope you're... What crime was that?
I'm going to continue to roll on this, just so you know. The Boston police tried to... This is case law right here. You got to study up on your law.
Oh, I forgot that you're a policeman.
You don't have to be abusive to me and threaten to smash me in the face with my camera because I took a photo and asked a question.
That's not what
This is the United States of America last time I checked. And I'm in public and you just made a bunch of noise towards me and I don't appreciate it.
I walked away from you and you followed me, okay? That's what happened. I suppose we'll have to seize your camera as evidence, right?
Yeah.
Would you be justified in seizing this photographer's camera, and under what circumstances could you do so?
I'm not seizing my camera unless you have due cause.
One final question. If you're the responding supervisor, what should you tell this officer and what action should you take with respect to this individual?
I want to talk to you this week about something that's come up in quite a few cases now and happening all over the country, and it's what we call a First Amendment retaliation claim, but you'll recognize kind of how that happens as soon as I begin to talk about it. Probably a good example case is out of Boston, Massachusetts. Mr. Glick happens to be walking in the Boston Common, which is the oldest city park in the United States, and it's an October night, and as he's doing so, there's an arrest taking place in the Boston Common. Mr. Glick's story is that he hears somebody say or shout out to the officer, "Hey, you're hurting him." Mr. Glick decides to film this arrest and make sure the officer sees him filming it. The court describes that Mr. Glick is about 10 feet away from where the officers are making the arrest. Hey, somewhere along the way, when the arrest is complete, an officer says words to the effect of, "Hey, you got enough video now." And Mr. Glick says, "Hey, I'm going to keep filming." And again, these are paraphrasing, but words to the effect of, "Hey, I'm going to keep filming. I saw you punch him." With that, an officer says, "Hey, do you have audio on that phone?" Mr. Glick responds that he does, and then he's subsequently arrested. Now, kind of an interesting case because the officer actually charged him, among other things, with violating the Massachusetts wiretap statute for intercepting oral communication in this public park. Bottom line is, the criminal charges were thrown out. Bottom line is, Mr. Glick then makes a complaint to the Boston Police Department. Doesn't really get investigated according to the court. And then subsequently he brings a lawsuit under Section 1983. He claims that he's got a First Amendment right to film the officers in a public place, and that by arresting him for filming in a public place, for exercising his First Amendment rights, it's what we call a First Amendment retaliation arrest. Hey, bottom line is the case proceeds, and it goes up to the United States Court of Appeals for the First Circuit. Hey, the United States Court of Appeals for the First Circuit says, hey, first off, a wiretap statute that doesn't allow you to openly and notoriously record is overbroad. So that's one of the things they say. That's kind of interesting. More importantly, though, they say that people do have a First Amendment right to film a public official in a public place. And there's really little law enforcement can do about it. Now, the court does say it's not an absolute right. There can be reasonable time, place, and manner restrictions. So, for example, I suppose that, just a hypothetical example, let's suppose that you were doing an accident out on the highway and someone was to stop on the highway where it's illegal to stop. They were putting themselves in danger. They're putting everybody else in danger. That person you could move along, and I think that's kind of the time, place, and manner restriction that the court would recognize. Something dangerous. Hey, one of the things, and I always think this is important to point out, the court cites to Houston versus Hill for this proposition. The United States Supreme Court in Houston versus Hill said that every citizen has a First Amendment right to verbally criticize and challenge an officer in a public place when they're making an arrest, for example. In the Hill case, an officer down in Houston was making an arrest, and Mr. Hill, who was an extreme activist, is yelling from across the street, "Hey, why don't you pick on somebody your own size? Why don't you come arrest me?" And the officer does. Officer arrests him for interference of some type of disorderly charge. Ultimately, it's thrown out. Lawsuit goes to the Supreme Court. And the Supreme Court says, hey, every citizen has a First Amendment right to verbally criticize and challenge an officer who's making an arrest. The court in Glick says, of course, if you can verbally criticize and challenge an officer who's making an arrest, of course, you can go that step further and film an officer in a public place. Hey, the court did leave this door open for the dangerous situation. And the First Circuit had a second case. It's Garrick versus City of Ware, New Hampshire. Hey, this is a car stop case. It's at night. Officer, a sergeant, I think his name was Kelly, pulls a car over. Second car pulls behind him. The second car is Miss Garrick. She's following the first car, a friend of hers, home to his house. And ultimately what happens is Miss Garrick gets out of the car with an actual camera and starts to film. Officer basically says, hey, you're not going to stop there. What are you doing? She says, hey, I'm following him home. I'm going to film this traffic stop. He said, well, you're not going to do it there. which I think certainly from a safety standpoint, you don't want her behind you while you're doing the traffic stop. Hey, the sergeant does call for a backup car because when he approaches the car, he asks the driver of the car, I think his name was Hanley or something like that, and he says, hey, look, any weapons in the car? And the guy says, yeah, well, as a matter of fact, I've got a concealed carry permit, so I do have a weapon in the car. There's no issue ultimately with the weapon, but the officer calls for backup because of it. Hey, when backup arrives at the scene, Miss Garrick has now moved, but she went across the street into a school parking lot or a parking lot, and she's actually filming across the street. Now she's about 30 feet away from the traffic stop. That officer goes and asks her for the camera. She sticks it in the console of the car, refuses to give it. Ultimately, she is arrested, and she's charged with violation of the New Hampshire wiretap statute for intercepting oral communication during this traffic stop. They get a warrant for the camera. Then this is the kind of funny part of the case is they determined that the camera wasn't even functional. So she actually got no video. She's arrested. Ultimately, she brings a lawsuit. Now remember, on both of these cases, and on most cases that we talk about in these roll call trainings, but if it's a lawsuit, they're on summary judgment and qualified immunity, meaning officers are trying to get dismissed out of the case, arguing, one, that behavior was constitutional, or in the alternative, even if it was unconstitutional, the law wasn't clear, so they should get dismissed from the case on qualified immunity. When a court looks at that issue, the court takes the plaintiff's story as the story. And so, remember, these facts, it may not have happened exactly this way, but for purposes of the motion, the court has to take the plaintiff's story in the light most favorable. Hey, bottom line, the officers argued in this case that this is exactly what the First Circuit was talking about. Because this was a traffic stop, it did have that element of danger, so you could have this time, place, and manner restriction on First Amendment rights. Ultimately, the First Circuit said no, this was not that dangerous a case. There was no evidence that anybody had told Miss Garrick to move from this second position she had moved the car to, which was 30 feet away. So ultimately, Miss Garrick prevails against the officers on their motion for summary judgment and qualified immunity. That's not the end of the story. There's another case, Sharp versus Baltimore, and this is a case where it's very similar to Glick versus Cuniff. Mr. Sharp is filming an arrest. Officers see that. After the arrest is complete, an officer comes over and says, hey, let me see the phone. I want to look at the video. You might have evidence on there. Initially, Mr. Sharp says no, but ultimately he relinquishes the phone. The officer walks away with it, and when he comes back and hands the phone back to Mr. Sharp looks in the phone, and all of his videos are deleted, including videos totally unrelated to this arrest which occurred. Bottom line is he brought a lawsuit, and this is a lawsuit by a citizen against the city of Baltimore. And this is an interesting case. We know that the federal government has authority to criminally charge an officer who violates constitutional rights under 18 U.S.C. 242. We know the federal government can come in and investigate an agency for pattern and practice of violating civil rights. But this is a straight lawsuit between an individual and the city of Baltimore and its officers. Federal government actually sticks their nose into this one. They send a statement of interest letter to the case, and then when the case is going to be mediated, they make all kinds of recommendations, including things like, hey, officers have to be trained that people have a right to film them in a public place. Officers have to be trained that they can't seize a cell phone and destroy the videos or erase the videos. They have to be trained on what limited circumstances there would be for them to seize a cell phone. Hey, there's even some federal consent decrees around the country where the federal government has gone in and investigated an agency for pattern and practice, and some of the things that come out in the agreement and that they have to comply with after the fact is creating policies that prohibit officers from interfering with a member of the public who's trying to film them, from seizing their camera, from arresting them, from seizing their phone, all of those kinds of things. Basic learning lesson from these group of cases is that we have to be very, very careful. People do have a First Amendment right, all citizens, to verbally criticize and challenge us. That right extends to filming in a public place. And I realize that there are some courts that are still giving qualified immunity on this. Some of our circuits still are. But the federal government has recommended that, we have policies in place, we train in place. And I will tell you that these cases are losers. Bottom line, you're doing your job in a public place, you get filmed. Bottom line is the best practice is just to let it go. If you really have a situation where you feel that the camera contains evidence, then we've got to try to get that evidence in the least intrusive means possible. And we can't damage or destroy in any way the video on the phone. If we do have to seize a phone, one, we should have supervisory involvement in that. Two, we should do it again in the least intrusive means possible, which would mean that, get it back to the person as quickly as possible. And in most cases, it's going to require a search warrant to even go into that phone. So again, one of the things that we say in a lot of these Fourth Amendment cases and even the First Amendment cases is you got to ask yourself, how important is this? And if it's not important, if we're reacting out of emotion, then forget it. Don't get involved in taking the phone or any of that. If we really feel there's a heightened government interest because there's something on that phone that may be crucial to a prosecution or determining criminal identity or something like that, that's different, and then we should take appropriate steps. Hey, there may be cases where a person crosses the line. And those cases are going to involve things like where they get right in the officer's face with the phone, so there's a close proximity that poses a threat to the officer while they're trying to carry out their function. I'm going to tell you that the evidence that's going to be available, both for prosecution but as well as to defend in those cases, is the video itself, which is going to establish whether or not there was an actual interference with the officer's ability to do their job or a comprising of the officer's safety. Hey, I want to thank you for joining us in this weekly roll call. Again, we try to bring you up to date, provide you with quick training bullets on various topics that are coming up in the courts. Do so in a manner that gives you great knowledge, diminishes the likelihood of a lawsuit against you, but at the same time does not ask in any way to compromise your safety.